Good morning, everyone, and welcome to our Beasley Allen webinar presentation, Camp Lejeune Overview and Litigation Update. So, just to set the stage for today's program, we've got less than 5 months remaining for Marines, family members of Marines, and civilians who are harmed by contaminated water at Camp Lejeune to file an administrative claim for compensation under the Camp Lejeune Justice Act. Now, the process to submit a claim by the August deadline is very detailed and requires substantial documentation for support. Here at Beasley Allen, we've got an excellent team of lawyers handling these claims on behalf of those affected to ensure that all of their claims are submitted properly and on time. Now, the head of our team, Rhon Jones, serves on the Camp Lejeune Plaintiffs Executive Committee and the Resolution Committee. And he and other members of those teams are working to develop reasonable settlement solutions for all impacted victims to ensure that they're properly compensated for their injuries. And today, I'm delighted to introduce 4 very important members of the Beasley Allen Camp Lejeune team: Rhon Jones, Tucker Osborne, Elizabeth Weyerman, and Marion Brummal. Together, Rhon, Tucker, Elizabeth, and Marion are going to discuss all aspects of the Camp Lejeune claim process. They're going to update you on the progress of the Camp Lejeune litigation, and they'll be taking your questions as well. So, before I turn the program over to our 4 speakers, and while we're waiting on the last of our registrants to join us, let's go over a few CLE housekeeping notes. First, today's webinar has been approved by the Alabama and Georgia State Bars for 1 hour of CLE credit. In order to receive full credit for attending, you've got to stay on for the duration of today's program. A link to today's presentation was included in the Zoom confirmation email you should have received when you registered. But by the end of this week, you're going to get another email with a certificate of attendance and an updated presentation and video link that'll include the slides from today's program. You can email your completed evaluation form to webinars@beasleyallen.com. This webinar is being recorded, and for those Alabama and Georgia attorneys participating by phone, please email us your name, phone number, and state bar ID number to webinars@beasleyallen.com. That'll help us ensure you receive full CLE credit for today's program. And hey, for those of you practicing in other states besides Alabama and Georgia, we're going to send you a certificate of attendance that you can present to your own state bar. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we'll be adding more webinars throughout 2024. Finally, and most importantly, if you have questions during today's webinar, I want to encourage you to use the question and answer feature located at the bottom of your screen. We're going to set aside time at the end of today's program to try and tackle all of the questions submitted by our viewers. If we don't have time to get to your question, you can send those questions directly to webinars@beasleyallen.com. That's webinars@beasleyallen.com. That will ensure that we get all of your important questions answered either today live or after today's program. So, with all of that out of the way, I'm going to turn the program over now to Rhon and his wonderful team. You guys take it from here.
Great. Thanks, everybody, for being with us today. We appreciate you being here. Thank you for being here. I think we have some good information for you today. We're really going to focus on the pending deadline to have administrative claims filed and the things that we think are helpful tips to get you in the best position possible, get your clients in the best position possible to have the administrative claim filed in a timely fashion and give you what we believe are some of the good things we've learned on how to do it efficiently and effectively. So hopefully this will be good for everyone involved. You'll learn some things today. So our team is ready to take it away.
Thank you, Rhon. Hi, everyone. My name is Elizabeth Weyerman, and today I'm going to be covering the Camp Lejeune Justice Act generally and how to file administrative claims, since, like Rhon said, we understand and are experiencing firsthand that this is the focus and the top priority before that August deadline this year. The Camp Lejeune Justice Act is part of a larger act called the Honoring Our Pact Act that was passed on August 10th, 2022. This is a very important date because this is the date that is used to determine the new statute of limitations or statute of repose for the act itself. So you have 2 years from that date, so August 10th of this year, to file administrative claims. The full text is available at the link on this slide, where the Camp Lejeune Justice Act is Section 804 of the PACT Act. Now, this is a really unique statute. The exclusive jurisdiction is in the Eastern District of North Carolina, but it's important to understand that this is not an NDL, so the JPML consolidation rules are not at play. Still, the Eastern District of North Carolina has some very specific filing instructions on their website. So prior to you filing any kind of civil action, which of course would be after your administrative claim is processed, you should familiarize yourself with those rules. Another distinguishing aspect of the Act is the burden of proof. In this action, the burden of proof is lower than what is generally used in civil litigation. I'm sure I'm telling y'all nothing new, but generally used is the preponderance of the evidence. So that's greater than 50%. But for this act, the standard is as likely as not. So that allows a proof that is at least 50%. You see the distinction, and you'll know that this is extremely critical for some of these cases, considering their exposure compared to their other risk factors. Now, the Act does also limit the government's defenses. The Act removes the immunity defense and the Ferris Doctrine from the government's arsenal. I'm sure you're also familiar with immunity, but the Ferris Doctrine is a defense that prevents members of the armed forces who are injured while on active duty to successfully sue the federal government under the Federal Tort Claims Act. I want to talk to you briefly about the fact that the Camp Lejeune Justice Act is funded by the Judgment Fund. So this is a permanent, indefinite appropriation that's able to pay monetary awards against the United States that are judicially or administratively ordered, and that's, of course, what we have here. What you need to know, though, is that the Act does not allow recovery for punitive damages, only compensatory damages. So that's why it's so important for you to know your clients, know their stories, and be able to creatively present their damages to try to maximize what they should be able to get. Now, we've already talked a little bit about how the statute itself imposes its own statute of limitations or statute of repose, and that supersedes North Carolina's standard. This also extends to death cases as well. So even if a decedent passed decades ago, this is still a viable claim. A prerequisite to filing a civil action, filing a complaint under this statute, is that an administrative claim must be processed or submitted. So this claim is not filed under the Federal Tort Claims Act. This administrative claim is for purposes of the Act. It only serves merely as notice to the government. So now I'm going to talk a little bit more about the administrative claims process and how to file your admin claim. There are 3 different options. You can file individually with the form that you see on the right side of this slide, or you can mail a CD-ROM, or the third option, which is the CSV, which is what you see in the bottom left of this slide. That's a comma-separated value type. Let's talk a little bit about this first option, which you'll also be doing in the next 2 options. And this first option is to file a claim form individually. That just means on its own. This is, again, different than the Federal Tort Claims Act. It's different than the standard 95 form that you would use there. So please, again, make sure that you're downloading the correct form, which you can find at the second link on this slide. There are detailed instructions in this first link about how to fill out this form, but I want to be clear that this is a complicated process. You're going to need a lot of intake information from your client, and Marion and Tucker will talk a little bit more about case workup with that. You will have the option with doing this claim form to either mail it to the address that's listed on this slide or email this form by saving it as a PDF with the last name of the claimant, comma, their first name, and the date of submission, which is the date that you sign the form. So not necessarily the date that you're sending it in, but the date that you sign the form. Now, if you have authorizations for agents for your claimants, that you're going to save those listed as the second bullet point, as you can see here. Then you would email the claim form with that authorization to that same email, include them in the same email, and email that to the CL claims email address, which with the subject line, the same as how you save the completed form. Now let's talk about the second and third options. These are probably more popular for y'all watching here because if you're filing 2 or more claims forms, the Navy wants you to do this either by CD-ROM or CSV. Now here at Beasley Allen, we're doing them by CSV. This allows you to pull the data. The Navy pulls the data from your mass filings, your mass sending of these claims forms. They pull the data and put it into their own system. So if you're doing this by CD-ROM, you'll burn the CD-ROM with 2 different folders. One folder you will label claims forms, and you'll put all of those individual claims forms I just talked about in that folder. And then the other folder you'll label authorizations, and you'll put all of your authorizations saved as how I just mentioned into that folder. You're going to mail that, the CD-ROM, with a cover letter. That's going to be, the cover letter will include a list of the different claims forms and authorizations that are saved on the CD-ROM, and you will mail your CD-ROM in that letter to this mailing address listed on this slide. Now, in the next slide, I will show you the cover letter. So here it is. This is the third option. This is what Beasley Allen is doing. It's a little bit easier in my opinion because you can email this. And this is the CSV. You saw that file on the first slide that I showed you, which was the green Excel spreadsheet looking file. Now, the form that you see on this slide is the cover letter that you mail in with your CD-ROM or you email in with your CSV. So this will show you it in a little bit more detail. It includes the unique ID that your firm creates for each claimant, their name, and the number that they are saved on the CSV or the CD-ROM. So you see there's a lot of organization needed. You're going to email that to the same email address with the subject line batch filing. So if you're emailing in a batch filing, easy, subject line batch filing. If you're emailing in just one claim form, then it's the last name, comma, first name, and the date that you signed the form and your subject line. So in this email with the CSV, you will attach the CSV and the cover letter saved as a PDF. Now, this whole process has taken a lot of communication between our firm and the Navy for us to understand how to do this. If you've tried to figure it out yourself and you're having difficulties, don't feel bad. We've been in the same boat with you and it's taken us some time. Now, if you have technology questions, or if the attorneys handling Camp Lejeune claims at your firm changes, then you'll want to email Jennifer Langley-Carnes. I've listed her email here in the slide. She has been a wonderful contact for our firm. She's very helpful. She usually responds quickly. If you do need to email her, make the subject line of your email CLJAIT issue, and this helps her organize her emails and respond to you rapidly. So I know that was a lot of process, but at this point, I'm going to hand it over to Tucker, and he's going to talk about verifying exposure for our Camp Lejeune clients.
Thank you, Elizabeth. I'm Tucker Osborne, and I'll be covering how we prove up exposure for an administrative claim. And before we verify exposure to toxic water at Camp Lejeune, we want to understand the background of the contamination at Camp Lejeune. So Camp Lejeune was opened in 1942, and water contamination has been documented to have occurred between August 1st of 1953 and December 31st of 1987. And on the next slide, you will find a map of Camp Lejeune. It's important to be familiar with this map as we speak with clients to better understand their story. I'm a visual person, so this map helps breathe life into their stories and helps me paint the picture for their claim. They tell me where they were on the map, or tell me where they were, and I'm able to see it on the map, and it really helps me help them. And different chemicals were present at different locations, thus allowing us to connect certain injuries to particular injuries, which Marion will discuss shortly. So moving on to the next slide, but before we file an administrative claim, we want to verify the exposure. The standard for exposure is provided by the Camp Lejeune Justice Act, which says that the claimant must have been present at Camp Lejeune for at least 30 days between August 1st of 1953 and December 31st of 1987. And as we just discussed, that is when the water contamination was documented. And this is from Section 804B of the Camp Lejeune Justice Act. So between these dates, claimant must have spent at least 30 non-consecutive days at Camp Lejeune per the Camp Lejeune Justice Act. And so with that threshold, how do we prove this? To do this, I think it's easiest to put the clients in two separate categories. First being the military or civilian military dependents, and the other being civilian. So category one, the military or civilian military dependents, these clients either were service members or were there at Camp Lejeune because of a service member, as a military dependent, a spouse, a child. And this category is the simpler of the two because we can order military records for the service member. And how we do this is by submitting the standard form 180 or SF-180. This SF-180 form is available at the link on the PowerPoint. You will want to fill out all pertinent information about the service member. It asks for branch of service, the dates within that branch of service, and other contact information and vital statistics. And but what's most important that you do on that SF-180 is request these two different documents. It's request the DD-214 and request the official military personnel file, or the OMPF. And once you've completed this form, you can submit the request to the National Archives and Records Administration at the link on point number 2. And when successfully submitted, you will receive a confirmation number with which you can check the status of the request on that same website. All right, so we've submitted the request through the SF-180. We get the records back. And usually that can vary in time between a week or two and a few months based on how easy it is for them to find the records and whether they can email those records to you or send them via mail. But once we receive the records, we will have a DD-214 and the official military personnel file. Now, the DD-214 is a certificate of release or discharge from active duty. This is the proof of military service. Now, this document may not place the service member at Camp Lejeune, just this document, but it's important in establishing military service. The OMPF, or the official military personnel file, is really what we will use to place that service member at Camp Lejeune. It is primarily an administrative record. It contains information about service history, such as date of enlistment, type of appointments or enlistment, the duty stations, assignments, training, and so on. Within this OMPF document is what will place the service member at Camp Lejeune is the record of service. And this serves as a log of where the service member was stationed and the dates that they were stationed there. It's very detailed every time they arrived and left. It's documented in that log. So this summarizes what we will need for our military and our civilian military dependents. The service records putting the service member at Camp Lejeune. Now, category 2, which we've established as civilians, and I kind of categorize that as a catch-all or other category, this requires us to be a little more creative. Now, this category includes claimants who may have visited Camp Lejeune or worked at Camp Lejeune. So if we do not have military records placing the claimant at Camp Lejeune, what can we do? What options do we have? Well, for people who worked at Camp Lejeune, we can seek and request employment records. For people who are at Camp Lejeune, we can ask if they have any photographs of them at Camp Lejeune, their family at Camp Lejeune. That would obviously place them there. Were they ever issued any badges? or receive documentation that they were there when they visited? If they lived there if they weren't necessarily a civilian military dependent, but they did live there, do they have any bills or other documents providing the address that would place them at Camp Lejeune? And then ultimately, it may come down to an affidavit where we have to submit an affidavit, and this is where we have to be extremely specific. So without a service connection, it's much more difficult to prove that the claimant was there for 30 days between 1953 and 1987. We obviously need more information. So what were they doing there? These are the questions that we want to ask all of our clients, but more importantly, the clients who do not have service records placing them at Camp Lejeune. So what were they doing there? What was the frequency and the duration of time that they were on base? Were they exposed to the water? In what manner were they exposed to the water? Did they drink the water? Did they bathe in the water? Did they cook with the water? Where on base were they? Who were they there with? Are there any witnesses who could confirm they were there? So these are questions that we want to ask all of our clients to help paint that picture of their claim, help us understand their claim, help us to submit their claim. And this summarizes how we verify the claimant's presence at Camp Lejeune and exposure to the toxic water. And we did get an update in this area from the joint status report filed with the court on February 27th. The government has agreed to produce electronic information on the Marine Corps' Network Attached Storage, or NAS, by the end of this month. This production should include muster rolls. Muster rolls are reports that document the military personnel attached to a particular unit or station within the Marine Corps, which could reveal where a Marine was present on Camp Lejeune and when. And the digitization of these records was part of a joint project between the Marine Corps and the VA that took place around 2013, 2015, and involves around 61 million pages of muster rolls that span between 1940 and 2005. So this is a positive development and should help us bolster our claims for Marines once this production becomes available. So with that, I will turn it over to Marion, who will talk to us about injuries.
Thank you, Tucker. My name is Marion Brummal, and I'll be addressing the injury side of the litigation. In addition to proving exposure, it's also essential to verify the details of the client's Camp Lejeune-related injuries. So first, I would like to delve into some of the research supporting a link between certain illnesses and their relationship to the exposure to those chemicals found at Camp Lejeune. I will then address how those diseases interact with different aspects of the Camp Lejeune Justice Act. Finally, I will address some of the more common issues associated with procuring medical records. The 2017 ATSDR report evaluated the increased risk of certain health effects for civilians and military personnel potentially exposed to volatile organic compounds, or VOCs, while working and/or residing at Camp Lejeune. The contaminants identified in the study include TCE, PCE, benzene, DCE, and vinyl chloride. A number of cancers and other health conditions were evaluated. Significantly, the study found an increased risk of cancers among those exposed at Camp Lejeune as compared to similarly situated personnel at Camp Pendleton. As Elizabeth alluded to earlier, the Camp Lejeune Justice Act requires an equipoise and above burden of proof, where equipoise is defined as evidence that is sufficient to conclude that a positive association is at least as likely as not, but not sufficient to conclude that a positive association exists. Rather than a preponderance of the evidence benchmark, this represents a nebulous 50% standard. Similarly, the sufficient standard is defined as evidence that is sufficient to conclude that a positive association exists. The following tables briefly represent some of the ATSDR report's conclusions on the association between the listed chemicals and specific illnesses. Now, it's worthwhile to note that the 2017 ATSDR report is not necessarily the end-all be-all for all potentially compensable injuries. Epidemiological experts are reviewing and compiling research with evidence linking the chemicals present at Camp Lejeune to other injuries not necessarily evaluated in the report. A new ATSDR report published in January of this year, for example, expands on the previous research, finding an increased risk was found for some types of leukemia, lymphoma, and cancers of the lung, breast, larynx, esophagus, thyroid, and soft tissues. Regardless of what specific injuries are ultimately found compensable, the Camp Lejeune Justice Act does restrict recovery to injuries that accrued before August 10th, 2022, the date of enactment of the law. There's a strong argument to be made that this deadline could potentially include later diagnosed injuries if treatment began before August 10th. For example, take a client with a diagnosis of essential tremors in 2021. A full-blown Parkinson's diagnosis can take years and require specialist input. If the Parkinson's was only officially diagnosed last year, for instance, but treatment for the tremors preceded the deadline, then there's a relatively strong case that the injury could be included in the administrative claim. Shifting gears a little bit, I want to briefly go over some of the injuries specifically related to the elective option, the current bellwether pool, and those listed on the short form complaint. The elective option encompasses 9 injuries. However, even the public guidance document for the elective option notes its shortcomings. For example, the guidance notes that cardiac birth defects are not included in the EO, even though the ATSDR determined there was sufficient evidence of causation for this category of illnesses. Cardiac birth defects include a wide range of illnesses that are difficult to evaluate similarly without fact-intensive investigation. Thus, the EO should not be construed to exclude other potentially compensable injuries for consideration. Rather, as they acknowledge, this route merely dispenses with having to prove causation. Now, as to bellwether cases, the Track 1 bellwether cases have been selected. These include 100 claimants with complaints already filed. The plaintiffs and the government, respectively, selected 10 cases for each injury. The court recently decided the next round of 5 injuries to be considered in Track 2. For your case to be considered for selection, you must first submit the case and required information to the Criteria Committee by the following deadline. For cases already on file in court, the leadership imposed deadline for such submissions is March 20th, 2024. That's today. For cases not on file in court, but in the administrative process, the leadership imposed deadline is April 5th. To submit one or more cases, you must request access and a password from leadership by emailing a request to criteriacommittee@belllegalgroup.com. As you can see in the next slides, there are a number of additional injuries listed on the short form complaint. As with the administrative claim form, there is also a section to list other injuries not specifically delineated therein. So as I'm sure everyone is aware, in addition to proving exposure, medical documentation will be an essential element for a successful resolution in a Camp Lejeune claim. Accordingly, I want to take some time to go over some of the common issues we've come across in verifying client injuries. Given the range of qualifying exposure from August 1st, 1953 to December 31st, 1987, more remotely diagnosed injuries can be especially difficult to confirm. With some exceptions, most states do not require doctors or hospitals to retain medical records for more than 5 to 10 years. Thus, obtaining the original diagnosing document for a potentially compensable injury can be problematic in many cases. Some ingenuity can come a long way in overcoming this obstacle. For example, you can ask the client if they were treated for the same injury by another provider, if they have copies of their medical records, or if they have or can get access to an online patient portal. Alternatively, you can request insurance and pharmacy records that may document the injury. A Walgreens, for example, may hold on to records for 2 years, whereas a mom-and-pop pharmacy may retain them longer. In addition to showing that a client was prescribed a certain medication for a certain condition, it can also be helpful in identifying the specific provider who prescribed that medicine. Notwithstanding, even if the original documentation is lost, it would be prudent to reach out to other medical providers who may have at least noted the alleged injury in the patient's past medical history. Whereas an oncologist's office might have purged the patient's biopsy results after 5 years, the patient's primary care provider may have retained at least some documentation of the condition. In the absence of a perfect record, some evidence verifying an injury will ultimately be necessary. A sworn affidavit, for instance, while helpful, will not likely be sufficient in itself if other supporting evidence cannot be found. With regard to military health providers, although the Veterans Administration and National Archives are generally less susceptible to the constraints of retention policies as compared to private healthcare providers, these institutions still have their own share of limitations. With the clock running on the deadline for filing administrative claims, it may be helpful to ask the veteran to access their My Healthy Vet account, the main portal for accessing VA records online. This can ensure immediate access for verification of injuries and potentially reduce client expenses. Many VAs across the country are backlogged, and requesting records via traditional means, that is, sending a request with a medical authorization signed by the client, can be a lengthy process. For instance, I recently came across a file where we ordered medical records from the Atlanta VA Medical Center over a year ago, and they just came in the other day. For treatment that occurred on base during military service, generally you will need to order medical records from the National Archives using an SF-180 for veterans, as Tucker mentioned earlier. For civilian military dependents, you can use a National Archives Form 13042. In addition to the usual authorizations, requesting medical records for a decedent usually requires a death certificate and something attesting to the client representative's relationship to the decedent, such as a next of kin affidavit or letters testamentary, for example. Notwithstanding, a next of kin affidavit may not suffice when ordering medical records from certain facilities. Some providers may require either estate documents naming the client representative as the personal representative of the estate or a court order before releasing records. Again, some ingenuity comes into play here. It's worth a shot to request uncertified copies of the medical records, and if that doesn't work, then you may want to try to request records from other providers or by any of the methods previously discussed. This demonstrates why it is essential to obtain a death certificate with the cause of death listed for a wrongful death claim. This provides at least some confirmation of the injury. Although the additional medical records will still likely be needed in the future, you should be able to obtain those records once the estate has been opened. So thank you all, and I'd be happy to answer any questions you may have on that.
Yeah, so Marion, thank you for that. I'm sure David will join us shortly, but again, you kind of see the theme here. We are wanting to provide information that we think will be helpful to get you through or your client through the administrative claim process. This is a unique statute. There are some strange things here, which, some of which have been discussed, some of which I'm sure many of you have already encountered, probably multiple times, frankly. So I want to be super clear on this point. This is a very relational law firm, and we want to help you with whatever questions or issues you may have. If you have the question today, as David has pointed out, you're welcome to submit that. If we can't answer it today on the webinar or don't get to it or whatever happens there, we will certainly reply via email. But even more importantly, if you're on the webinar today and you have a question that comes up tomorrow or the next day or next week, please reply or send an email to the suggested address, which I think David gave. Did you give that, David?
I did.
Okay.
It's
so
webinars at beasleyallen.com.
And it's out there. Of course, I'm here, Marion's here, Tucker's here, Elizabeth's here. We have many other lawyers working on these cases as well. So I really want to stress that idea of, I think it's probably not a matter of if, but when that question comes up or that frustration comes up or that issue comes up. If we can be of any assistance, we want to try to do that. We believe that by helping, everybody, we hope that it's better for all the claimants, which is really what we're trying to do here is help these clients get some much needed relief. So, just again, want to be super clear there that's the goal, is to try to get everyone the help and information they need for their particular clients.
Thank you, Ron, and thanks to your entire team for really a fantastic presentation. We've cut the presentation a little short today just by, virtue of us having a lot of questions that need answering. And as Ron said, that's our number one objective here, is to get your questions answered. So, panel, if you'll let me start things off, our first question comes from Molly. Molly asks, we've recently tried to submit claim forms by CSV and we're told to hold off because the portal was coming in February 2024. Do you have any updates for us on the portal?
Yeah, so I'll try to start with that one. I don't have an update on it. It was discussed at the March 5 status conference, and the Navy, at least was my understanding, said what the question says, that it is forthcoming. I don't think it has occurred yet, or it has not occurred in full. So, again, not trying to predict what they may or may not do. I'm sure they are giving it a good effort. But as anyone who's been involved in this litigation knows, what they say they'll do, it does not necessarily occur as soon as they say it will be done. So, but Tucker, Mary, and Elizabeth, you may have other comments.
That's exactly right. We are being told that it's forthcoming and taking a wait and see approach on when exactly that will happen.
Yeah, and then just for what it's worth, I think that's it looks like okay. I would go ahead and submit, anyway, because the portal may be up tomorrow. It may not, and so I don't think I would hold off, but I understand the question, and that's what we know about it.
All right, let's move to our next question. It comes from William. He asks, I have one claim where the records have not been produced and it has been more than 6 months. An SF-180 was submitted. I tried to call, but can never get through. Any suggestions?
Team, what are your thoughts on that?
I'd say we've encountered this numerous times. With some people, you can get the records within a week. Some are still backlogged for months. One thing you want to double check is on the third page of that SF-180 to make sure the request was sent to the correct place. But, barring that it was done all correctly, it may be worthwhile to keep trying to follow up with them. But I know that there is likely a huge backlog for people requesting the full set of military records.
All righty, thank you. Our next question comes from Tristan. He asks, do award plaques with client's name, as in ones that include a mention of Camp Lejeune, count towards proof of service?
Yeah, I'll start there and say that probably this case has presented more unique opportunities to provide proof, if you will, of especially exposure or presence. I don't know about count, but I do think that there are various ways to supplement your argument over exposure and presence. I don't see why a plaque wouldn't be, potentially part of that submission, the ability to do that. But our team may have had this come up in a more particular situation.
Right, and this litigation where the exposure period started 70 years ago, we welcome anything that the client can provide that would place them at Camp Lejeune. And just like Ron has said, I think it's, in this case, probably a great supplement. We may want more than that. I think an affidavit on top of that would be stronger. And if there's obviously any other documentation that would absolutely put that client at Camp Lejeune. And I think the issue with the award may be the 30-day requirement.
Yeah, and it may be
that's certainly a start.
And it may be that the plaque or the details of the plaque lead you to other information that you may be able to make a request for, confirmed documentation of. So I would probably look at that. You can probably dig for a little more information with your client's history. The plaque, I think, would certainly be an important part of that inquiry. By and of itself, I'm not sure, but again, I think it would be part of what you're doing to try to dig into that verification.
All right, Rhon, Tucker, thanks very much. Our next question comes from Megan. Megan asks, do you have a template affidavit that is being used for claimants that are unable to find documents or records that they were at Camp Lejeune? You may have already addressed that a bit, but is there a specific template or affidavit that can cover that?
Yeah, I don't know about template, but I do feel comfortable, and of course the team may well add to what I'm going to say. I do feel comfortable that when you look at a particular client situation, depending on those specifics, that we do have kind of base affidavits, and we're happy to share, those with you as to what they say. Again, template is that's probably fair, but it has to be made specific, with the certain situation and circumstances that you have for that client. But we're happy to share what we have done there. And team, you may want to add to that.
Sure, and that also rides on what information is available from the client. What are they able to tell you about their exposure? I listed off a number of questions that we would want to ask the client, and as many of those that we can answer in as much detail as possible, we want to include that on the affidavit. And I'm sure there's plenty of questions that I left off as well. So, I don't think we have necessarily a template that we will submit in this circumstance, but we do try to answer as many questions as possible.
Yeah, and I want to stress too, wherever this question is coming from and whoever's sending it, we will absolutely reply to you and provide affidavits, perhaps redacted, of course, but we can send you things that we've used to try and help you with whatever your situation is.
All right, thanks, guys. Our next question comes from Dennis. Dennis asks, eVet Rex specifically asks whether the request being made pertains to the Camp Lejeune Justice Act, and if so, makes it clear that a request should not be made. So are some people ignoring that or just selecting no to obtain records?
I'll let the team take a crack at that.
I don't know the specific answer to that particular question, but kind of our contention is we want to have some verification of the injury so that we can vet the claim before filing. Now, whether that entails asking the veteran to obtain the records themselves or we get them by an alternative means, essentially, we just want to ensure that we're not making any frivolous claims. And also, we might find other injuries that the veteran didn't mention that could be potentially compensable that we can add to the claim.
Very good. Our next question is from Julian. Julian asks, if your subject line for a CSV submission was something other than, quote, batch filing, do you need to resubmit those claims?
I'm happy to answer this. I would not resubmit it because we've been told that the 6-month review process begins when they open your email, and they should respond if anything is insufficient. So hopefully everything is fine there, and just correct the action now as you go forward.
All right, thanks, Elizabeth. Our next question comes from Robert. Robert asks, will the muster rolls and other documents be made available to all claimants? If so, how will these be shared or accessed?
Yeah, so the plaintiff's leadership has filed a motion to compel for at least certain digitized muster rolls. So I believe that is pending. The leadership has also filed, for example, a motion to compel production of the an ATSDR water modeling project file, which the court agreed with our position on. So as to when the muster rolls are made available for everyone, I think it depends in part on what happens with the motion to compel on the digitized aspect of it, which is, a lead into your question. But Tucker or Marion or Elizabeth, if you have additional information, please, please provide input also. I
Right,
think
and
the
I
answer
think we
is,
know,
go ahead, Tucker.
I think we know about as much about how the muster roll sharing will work as we do the portal. We know that that is the intent. We don't know how exactly that will play out. So that's something that we'll also have to wait and see on.
All right, thank you. So James has a quick follow-up question. I believe this may be a follow-up to one of your remarks, Marion. James asked, you just mentioned an April 5 deadline for certain injuries. How does James get clarification on that?
Right, and that only applies if you are interested in having your case considered for track 2 of the bellwether cases. And the deadlines refer to when you need to submit that application to leadership in order to be considered. So if your case is already on file in court, that submission deadline is today. And for cases not on file in court, but in the administrative process, that deadline is April 5th. So this is not a mandatory deadline, only if you're interested in having a liver cancer, kidney disease, prostate cancer, breast cancer, or a lung cancer case considered for bellwether selection. And I would encourage everybody to go to the plaintiff's website for leadership at camplejeunecourtinfo.com, and that should have all the latest updates on the litigation.
Yeah, and Marion's exactly right. But just to be very clear, these are bellwether track 1, track 2 issues. These are not administrative claim filing deadlines. They're not. Those two are very different things. And so Marion did an excellent job of clarifying it. But that's, you see the point there.
All right, our next question comes in from Jen. Jen asks, if the deceased client's injury is listed on the death certificate, will we need medical records in the future as well, or will that death certificate injury notation suffice?
Marion, you can take first crack if you like.
Sure. Now, while the evidence on the death certificate is great for your claim, if possible, I think it would be preferable to have additional medical records confirming the condition. And maybe that'll play into the onset of the injury and learn other factors that may be essential for your case. So, I mean, if that was the only information you had, I think you would have to roll with it, but I would do everything I could to get additional medical records showing the earlier onset of the injury.
I would agree with Marion, because we don't know exactly how things are going to play out. As he said, if that's all you have, then that's all you have. Whether that'll be sufficient or not, remains to be seen. But I do think it would be prudent to, if you know what that is, and there is a way to get or attempt to get additional records, and it could be through various sources, I think that would be wise to try to supplement, the death certificate.
Good advice. Thank you. So our next question comes in from David. David asks, for death cases, in order to allege wrongful death in that case, does North Carolina law apply? Specifically, do we need to create an estate to do it? And David just notes other states allow statutory beneficiaries to file in their own name without an estate. And where must the estate be created? If so, North Carolina or the current filer's state, i.e. where the death occurred. I know that's a multi-part question. I can break that down again for you, panel, if you like, but who wants to take a stab at that question about the application of North Carolina law to wrongful death cases?
Yeah, so I'll start and then others may join me. So with this particular question, given the subparts, I think this would be a good question for us to reply by email as well, so that, because there's some nuance here. There has been at least one ruling I know of, for instance, in a summary judgment related to what's normally referred to as an ancillary estate in North Carolina, and whether that would be sufficient. The ruling, as I recall, said that would not be sufficient. You would need, an estate opened. So there are some things that are kind of set here that we know from rulings by the court thus far. I still believe there are some things that we still don't know as far as what rulings are going to be there in the future. But that was pretty broad. Tucker or Marion or anyone, do you want to take a crack at any aspect of that?
Yes, what we do know is that an estate will need to be open before we can submit an administrative claim.
And we do, and Tucker's right, we do feel comfortable there. So kind of, as it pertains to the subject of this webinar, step one, we do believe an estate is required for the admin claim. The other subparts here, I think we can provide answers. But again, I think an email would probably be better than going beyond the admin claim today.
Okay. And sort of a related question to that one comes from Thomas. He asked, is local counsel required if the client and or firm are out of state?
Teams, anyone want to take that one?
If your client and firm are out of state, I shouldn't have thrown the and or in there.
That's okay.
So if both client and firm are out of state, is local counsel required?
Not if the attorney's barred in North Carolina. So if the firm's out of state, you will need a North Carolina attorney. If not, then you will need local counsel.
Okay. Next question comes from John. John asks, do you submit claims for veterans at New River?
The answer to that is yes. And some supporting evidence for that is that claimants who are exposed at New River are specifically mentioned in the elective option guidance. So we are filing claims for veterans that were stationed at New River.
Perfect. Next, we've got a question from Beth. Beth asks, is there any information on response time for elective option claims that have been submitted?
Yeah, so my experience there is that it varies. I don't believe there's any real set time period. I think that the general response has been, we're getting better and better with this. EO is getting better. It's getting faster. I'm not honestly sure that's accurate, but how to say this, I think it has been somewhat slow in the way that it's worked and the way that it was presented versus the way that it's actually operated have been, in my opinion, mine only, quite different. So I don't, team, you may want to add to this, but I would say it has varied a good bit here. So
That's right. It's hard to determine if there's a pattern in the time of the responses. We do know that the number of responses has been low, and we do hope that picks up.
Yeah, and frankly, the number of offers, under EO have been low compared to what's out there. So, again, not trying to be super critical of any entity. Just A, I don't think there is a set time, and B, the number of offers has been, I think, far fewer than most people envisioned.
Okay, we have sort of a related timeliness question from Jennifer. Jennifer says, we sent a claim in August 2023. CL recently sent an email saying they received the claim in January 2024 because that's when they activated it. And Jennifer's concerned that it was there 5 months prior. Is there any need for concern on her part, or can you kind of address that delay?
Elizabeth, any insight from you on that?
Yes, I would say that we are going off the date that they say they received it. So if you do plan to file a lawsuit, you would do so in July of 2024. And that just goes back to the timing that Rhon was talking about. It is taking them some time to go through everything. So that's the timeline you're going off when they say they've received it.
Okay. Next, Heather asked, is a claimant who cannot find medical records, and in her case, they've checked pharmacies, other providers, etc., and records simply don't exist or don't still exist. Are those folks just out of luck if they would only rely on an affidavit? It sounds like that wouldn't be enough, but I want to leave that to you guys and what your thoughts are.
Yeah, I think on that one, David, it would depend on the facts of the situation. You know, if it was a relatively recent bout with medical records, pharmacies, for et cetera, then I think that's a little different. In other words, one would think, there should be records there. As I think was mentioned in the webinar today, there's some instances where records just frankly aren't kept beyond 5 years, 10 years, 20 years, 25. So I think if it was a long time ago and you could show that it's just not doable, then I would lean towards an affidavit again to give you some basis for it. And then you could work through whatever the facts were. I think it's probably less likely if it's more recent and the records, should be there. I think there's a bit of a defining line between when stuff stopped being kept and when it didn't, depending on the provider and the date of the injury, the date of the treatment, et cetera.
I think we've got time for 2 more questions. And for those of you, hey, if we haven't reached your question, again, please send those to us at webinars@beasleyallen.com. Our team will be happy to get back in touch with you just as quickly as they can. So second to last question comes from Terry. Terry asks, if the case is for a service member, would they be disqualified in the claims process if they were dishonorably discharged from service?
Yeah, and based on my reading of this, there's really no requirement about their discharge status. Now, compared to other VA-related Camp Lejeune programs, I think there have been requirements about having either a general or honorable discharge status. But the way I've read the Camp Lejeune Justice Act, it merely applies to those who are exposed to the water at Camp Lejeune. I didn't see any qualifiers on that.
Okay. And our last question for this presentation comes from Heather. Heather asked, have there been any updates to including Camp Johnson claims? She's had several vets reach out to her that were stationed there, and it's her understanding that the water at Camp Johnson wasn't contaminated. Does anybody want to take a stab at that?
I would say I would look at the case specifically, but I think that might be something you want to include. Talking to so many veterans, you can ask about their service. And for example, people who were at Camp Geiger, routinely did training exercises on the main base. So, I would look at the facts of it, but, depending on that, it likely would be something I would be comfortable with pushing forward for filing, given the geographical connectivity to the main base and the fact that so many veterans went across the main base.
Thank you, Marion. We sure appreciate it. And again, I'm so sorry we haven't had time to get to all of your questions this morning, but want to encourage you to send them in. Our guys will be happy to answer any and all of your questions. And for those of you who may have missed our earlier CLE announcements, just a reminder that by the end of this week, you're going to receive an email with a certificate of attendance and an updated presentation with the slides and video link. You can email your completed evaluation forms to webinars@beasleyallen.com. Again, for those Alabama and Georgia attorneys participating by phone, very important, you email us your name, your email address, phone number, and state bar ID number. Again, that also goes to webinars@beasleyallen.com, and that will help us ensure you receive full CLE credit. For those of you practicing in other states besides Alabama and Georgia, you're going to take the certificate of attendance we send to you. You can take that and present it to your own state bar. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we're going to be adding many more webinars throughout the rest of this year. Thanks to everyone for joining us today. Thanks, Camp Lejeune team, and thanks for supporting our Beasley Allen webinar series. Have a great rest of your day.